I don't want to frighten you, but if you're a claimant, there is a new risk, which is in fact an old risk that has been resurrected. And that is a concept that was called striking out for want of prosecution. Up until the civil procedure rules came in, as they did on the 26th of April of 1999, under the old rules of court, there was this concept called striking out for want of prosecution. And as the name probably suggests, the idea is that if you were bringing a claim, but you failed to prosecute it, to pursue it, then the court would ultimately take the view that it was wrong to let the matter drift on and would strike it out, even if the case potentially was a really good one. Now, striking out for want of prosecution as a concept was swept away as the rules of the Supreme Court were swept away in 1999. But there are two recent important decisions that you need to watch out for. And the single point I ask you to remember from this little chat is that if you are a claimant and you issue proceedings, for goodness sake, get on with those proceedings. Now, the two cases that have caught my eye, firstly, in 2015, late 2015, there was a case called Solland and Harris. That was a case where the claimant was 31 months late filing a court questionnaire, and the defendant boldly applied to have the claim struck out on the basis that this delay represented an abuse of process. And abuse, of course, is enshrined in the new Civil Procedure Rules, Part 3.42. Well, the master agreed with the defendant's submission. 31 months delay, didn't that tell you that the claimant had no appetite, no intention to get on with the case? And that the action, therefore, was clogging up the arteries of the court system, and the right thing was to strike it out. Why? Because the claim, a professional negligence action against a firm of solicitors, was put at £4 million. So on account of the failure to file a document, the defendant walks away, and that decision was upheld on appeal to the High Court. We've just had another case before Master Matthews called Phelps and Button, and the intriguing thing in Phelps is that the claimant had actually won, in that back in 2007 the case had gone to trial just upon liability, and the claimant won the case. So on the back of that, there is now an order that the value of the claim be determined, and directions were given as to preparing for the assessment of quantum hearing. Those directions were not obeyed, and in 2010 a further order was made to hand over documents and to produce expert evidence so that one could work out how much the claimant was entitled to. That order was not obeyed either, and now, 6 years on, the defendant applies to have the claim struck out once more as an abuse of process. And Master Matthews duly obliged. He said that the defendant had been denied the opportunity of a proper trial because even if you're liable in principle, it is still for the claimant to prove their case and to demonstrate what loss they have actually incurred. And with all these years going by, the opportunity to investigate, to quantify, was diminished, and the defendant could not therefore secure the quality of trial they would have got had the matter been dealt with promptly and taken to a hearing in probably 2008. So with that, again, the claim was struck out. So if you think about it, the winner is the loser because they did not press on with the claim. Now, this fits in very much with recent thinking in the Court of Appeal. I need only mention one case, Denton, where Lord Justice Jackson said that it was the duty of the parties to get on with cases and get them to a hearing, to resolve them, and not to procrastinate. And just a final thought about Phelps. The claimant tried to put some of the blame for delay upon the defendant. That argument was brushed aside by the master, who correctly said that if you're the claimant, you're making the running. After all, you're the one who issued the proceedings. You're the one who started this, and therefore you have the burden, you have the carriage of the litigation. And with that, the claim was dismissed. So in essence, if you issue, get on, don't delay, obey orders, rules, directions. If there is a reason why you can't proceed, for example, you might have to wait for a final medical prognosis, then tell your opponent, tell the court, and think perhaps about getting the blessing of the court and securing an order for a stay of the matter pending the acquisition of the material that is necessary. But beware, a whole new game